And I'd first like to welcome everyone. We are excited to launch a new initiative here with Houston Volunteer Lawyers in partnership with the Houston Bar Association to begin taking cases for juvenile record sealing. This is a fantastic initiative for us to be able to give youth offenders a second chance. And we're very pleased to have Katya Dow here to give us a training for how that process works. So just to start, to give you some insight about, sorry about that, hold on. To give you some information about Houston Volunteer Lawyers, we are the pro bono or service arm of the Houston Bar Association, providing free legal services to over 500,000 low-income persons in the Harris County and Houston area. We also promote volunteerism through our attorneys in the private bar. And so we welcome everyone who's on the call today to sign up to be a volunteer. And if you have questions about the types of cases that we have and the types of volunteerism that we can provide for you, please reach out to us. In particular, the new Attorney Pro Bono Project, we're calling all newly licensed attorneys. If you attended any of our previous CLEs, one that was in the end of January on expunctions and non-disclosures, we have those cases ready, as well as for the juvenile sealing. And so if you are a newly licensed attorney from February 2020 or last year for any of those bar administrations, we welcome you to sign up to be a volunteer. It's a great way to learn some practical skills, have hands-on mentorship through the staff attorneys at Houston Volunteer Lawyers, and it also allows for many of us, myself included, to really get our feet wet and have that first experience and it be a positive experience on some of these cases. The project team for the new Attorney Pro Bono Project includes Veronica Jacobs, who is our Director of Advocacy and Community Services. Myself, I'm a staff attorney and a fellow through the Association of Women Attorneys, as well as Henry Sturm, who is also a staff attorney and a pro bono fellow through Hutton Andrews Kurth. Our email information will be communicated at the end. So if you have specific questions about the new Attorney Pro Bono Project or about our CLE series, feel free to reach out to us. And so now I will turn it over to Katya Dow. She's the Supervising Attorney and Legal Programs Director at the Juvenile and Children's Advocacy Project of Texas. And Katya, I'll let you introduce yourself and then begin your screen share.
Thank you, Brittany. I appreciate that. And welcome, everybody. Thank you all so much for attending this CLE and considering taking a record sealing case. I would like to impress first upon all of you that this is a perfect type of pro bono project for somebody to take on, especially if you're a new lawyer. It is, not only is it important work, and not only are you changing somebody's life for the better when you seal their records, but it's also pretty feel-good work in a short amount of time. You can generally wrap up one of these cases from A to Z in about a month. And that's rare in the legal world to be able to do something like that and have an outcome that happens that is a good outcome and that is satisfying and that happens in such a short period of time. So I find that everybody that I know that I've trained to do these, including my students and other pro bono attorneys, really enjoy taking these cases. So now I'm going to try to share my screen. Okay. Is that visible, Brittany?
Yes, you are all set.
Okay, great. Okay, so as Brittany mentioned, I am the Legal Programs Director and co-founder of the Juvenile and Children's Advocacy Project. We are based at the University of Houston Law Center, where I am also a law professor. I've started the JCAP clinic there, and part of our programs, we have basically three main programs. We have our juvenile record sealing program, a direct juvenile representation program for kids who are involved in the foster care system and who have picked up a juvenile offense. And then also the third one is our school discipline representation program. Our record sealing program was the first program that we began, and that was we started that in January of 2015. Since that time, we have sealed over 600 juvenile records. And along with the HBA, which is now going to be you all, the HVL, we are really the only program in Harris County providing sealing of juvenile delinquency records at no cost to anybody seeking to seal these. And we do this for all offenses, including from the very most minor deferred prosecutions to felony offenses. We work directly with the Harris County Juvenile Probation Department to obtain complete background and eligibility checks. That's how we know that the cases that we are sealing are complete. We're not only sealing part of a record, which can happen if you don't have the access that we have through HCJPD. We also get our referrals directly from HCJPD, and JCAP personally gets a lot of our referrals from people who have already been impacted as adults from their juvenile records. And that's how we know what the impacts are, because we deal with clients who come to us when they discover they've had a juvenile record that they thought was sealed but wasn't. What are some of the collateral consequences of unsealed juvenile records? They can affect people in a myriad of ways, including in applying to college or obtaining financial aid, going into the military, applying for public housing or benefits. Many types of employment are affected. Mostly areas like childcare, healthcare, home healthcare, or anything requiring licensing. So it's not all employment. So if they're trying to get a job, say at McDonald's or something like that, FedEx, generally those employers do not do the types of background checks where juvenile records will come up. Any future court proceedings will be affected. Immigration proceedings are affected. If you're trying to obtain employment with the police department or a probation department, that's definitely something where a juvenile record will impact you. And of course, law enforcement has access to these records, and so it will affect how future offenses are handled. Part of the problem right now is that many people don't even know that they have open juvenile records until they realize from an employer or a military recruiter that they have a record that is still there. Lots of times they're given bad advice, whether it's through probation officers or through their attorneys, that their record is going to be automatically sealed. And the reasons for this are, well, this has been happening ever since juvenile records started being created. There was always this sort of idea that these records are supposed to be going away automatically. And we're going to go into how the law has changed in 2017. That makes it even more of a reason that people think that their record will be being automatically sealed, but it's still not actually really happening the way it's supposed to. We have adult clients calling us every single day asking for help because they have been negatively impacted. Other collateral consequences, in addition to those ones that I just mentioned, since as I mentioned, we represent kids who are in foster care and have picked up juvenile offenses. Those kids, very often, if they are in long-term foster care, they have been moving from one placement to another throughout Texas, throughout various counties in Texas. And very often they also pick up offenses in those counties because they run away from their placements and get into trouble. And so when they age out of the system at age 18, they have a slew of offenses in various different counties, and they don't even know, number one, which counties they're from or what types of offenses they are. And without having access to a probation department like we have that gives us the access that we need, you are unable to actually get that information. So these kids have no ability to figure out where their offenses are or what they are. And so it is almost impossible to get them sealed in all of those counties. Thankfully, we do have that access. And so we are now branching out into other counties to seal these records. Kids in foster care have other collateral consequences in addition to the ones mentioned before. They have immediate problems with placements if they have a juvenile offense, depending on what the offense is. Sometimes they can only go into emergency shelters for long periods of time because the placements will not take them with certain offenses. Once they start to transition out of foster care, independent living programs become much more difficult. Any police interactions they have from that point forward are affected by having a juvenile offense. and they have worse outcomes in their adult criminal cases if they do end up picking up another adult offense. As I mentioned, this is meaningful work and it is feel-good work. We just really love the telling a client, you know, guess what? Your record is sealed. You now can move on as if this never happened. And it is a psychological shift in how these clients see themselves and how they move forward in their own lives. It's something that's really fun to watch, and it makes you feel good about being part of that process. It makes you feel good about being an attorney. These are just some of the things that clients have told us after we seal their record, and it's truly inspiring because you feel like you've really done something that makes a difference in somebody's lives in a possible way, in a positive way. So who has a juvenile record? Once somebody is arrested, once a juvenile is taken into custody, that's what it's called in juvenile law, they are immediately fingerprinted and their information goes into the Juvenile Justice Information System as well as to the FBI. So that means that even if that case somehow after that is not actually charged and everything is dropped because, for example, there is, you know, not enough probable cause to move forward, they still have a record in the system. So they may erroneously think that, oh, okay, that case went away, I don't have to worry about it, but there's still a record in the system that looks just like a juvenile record or even an adult record that was adjudicated. As an example of this, we had a young man come to us several years ago when he was 16 years old. He was walking down the street with a friend of his, not doing anything, just walking down the street. And there was a robbery that occurred several blocks away. And apparently the police thought that they matched the description of the two men that committed the robbery. And so he and his friend were taken into custody. And it was very soon discovered that they had absolutely nothing to do with this. There was no reason for them to have even been brought into custody. However, they had been detained at that point and their fingerprints had been taken. And so there was a record in the system. But they were told, okay, we're dropping this for lack of probable cause. No worries. You don't have to worry about it anymore. And our client, this young man, went on to go through a criminal justice program at University of Houston. And he did great. And he wanted to go work for HPD. And he got the job, actually. And then they ran his record and they came up with an aggravated robbery charge. Obviously, he'd never had anything to do with this and, you know, could even show that this was not something that these charges were dropped. However, he was unable to be employed by HPD because of this record. Since that time, the law has been changed somewhat so that if a case is dropped, if the charges are dropped for lack of want of probable cause, then those records need to be immediately sealed. However, charges can be dropped for a number of different reasons, not always just for lack of probable cause. So if that's not the reason, then that record will still remain and needs to be sealed if you don't want it to be on your record anymore. Additionally, cases where we have a lot of really great, there are pretrial diversion, pre-adjudication diversion programs in Harris County where kids that have really minor offenses can just take a course, like a 1 day little class for something, especially like minor drugs or shoplifting. And then if they do what they're supposed to do, if they stay out of trouble for either 3 or 6 months, then again, those charges are dropped and nothing ever happens. They don't even have to go into court. However, it's still, since they have been taken into custody and fingerprinted, there's still a record that remains that if you don't seal it is discoverable and can affect you negatively.
Katya, I'm sorry to interrupt. Before you move on, we do have a question about some of the acronyms that you've used.
Sure.
NS, JJIS, or DP. Can you explain those further?
Okay, so JJIS stands for Juvenile Justice Information System. DP, that is one of these pretrial or pre-adjudication diversion programs. They are just commonly referred to as deferred prosecution programs. It's sort of a misnomer because there's also something that happens in court that can be called deferred prosecution. So they're really more aptly called pretrial diversion programs, but they have short names like DP 90, DP 180. And then I'm sorry, what was the third acronym that I didn't explain?
NS.
Okay, that was a client, those were client initials. So that's why I didn't explain that.
No problem. Thank you. And I will ask, and forgive me for this not checking on this before. Would you prefer that we wait for the questions for the Q&A, or would you like to answer them as they come?
I personally like to answer them as they come because I just feel
Okay.
like then they're fresh. So I don't mind being interrupted at all.
Absolutely. So we do have one question from an attendee asking if you can review tobacco cases and the process under the health code. Whenever you are able to reach that question.
Sure, absolutely. That's probably something that's better because those are actually different types of cases. Those are adult cases. They're Class C misdemeanor cases, and there is a different process for those. So I'll go into that after at the end. Okay, so regardless of whether the child's conduct was adjudicated, that child still has a juvenile record with the Department of Public Safety and the Federal Bureau of Investigation and several other agencies, which we'll go into. And that is a permanent record until and unless the record has been sealed or you take the steps to seal it. These are all of the agencies that hold juvenile records once it goes into the JJIS or Juvenile Justice Information System. So the first one is Harris County Juvenile Probation Department. The DA's office will also hold these records, obviously. DPS, which is the Department of Public Safety, is also known as the Texas Crime Information Center. They are the central repository for all of these records. The Harris County Sheriff's Office, and then of course the arresting agency will have a copy of these records. And as we said, the FBI also has a copy of these records, but I include that in with the Department of Public Safety because they're the federal version of the TCIC. Then usually schools and the school districts will have a copy of these records. And that is because for most offenses, police officers are required to notify the schools within 72 hours that an arrest has occurred or somebody was taken into custody on an offense. So very, very often, most records will also be held by the school districts. The Department of Family Protective Services will also have a copy of these records if the child is involved in the foster care case. And TJJD, which is the Texas Juvenile Justice Department, will have these records, but only if the child was committed to a detention facility post adjudication. If they were brought into the detention center and if they stayed there prior to any adjudication, there will not be a record that is sent to TJJD. Who can get access to juvenile records outside of these agencies? So the good news is that you can't just go on Google and do a record search and find these records. So juvenile records have a layer of protection that adult records do not. However, there are many entities that can access these records: state agencies, federal agencies, law enforcement, prosecutors, colleges. And then there's a catch-all phrase that says anyone with a legitimate interest in the matter. In 2017, there was a real big push to try to constrain the numbers of agencies that could have access to these records. And they did make an improvement because it used to be that there was actually a list of all sorts of agencies, including tow truck drivers and all sorts of crazy agencies that could get access to these records. They were successful in really bringing that down to just much fewer agencies that can have automatic access to these. However, it's very vague. So we don't really know who's getting access to these agencies anymore, or access to these records anymore, other than the fact that we have clients coming in telling us, okay, my employer, my current employer, or somebody who I just applied for a job to told me I have a juvenile record and I didn't even know it was accessible to them. And that's how we're being educated about that too. I've had conversations with general counsel for TJJD who worked on this statute in 2017, and she's actually surprised by the access that some of these agencies are getting. So it's really something that's unclear right now as to who all is really able to obtain access to these records. Every week we learn of a different employer or entity that has gained access. So what do juvenile records look like in background checks? So one of our clients, so when she was very young, I think 13 or 14, she stole something. I think it was like lipstick or something from a store. And she ended up in one of these, like I mentioned, DP programs or pretrial diversion programs, where she just had to take a little class and then the charges were dropped. And she was told, you don't have to worry about this. It's not, it's, you don't, this, you never had to go to court. You don't have to worry about this case anymore. However, she became a securities broker and was working for a company for many years. And then suddenly one year recently, her juvenile record came up and it looked like this. And I thought this was interesting because we hadn't actually really seen what these look like, because not always do the clients get copies of what this looks like on their record. And as you can see on the left-hand column, it says, the date of the offense, and then it says charge 1, theft of property. And then over to the right, it explains what that theft is a class B misdemeanor, and that, what category of offense that is. However, it doesn't say anything about the fact that, number one, that this was a juvenile offense, and number two, that this was a case that was never prosecuted. It was that, or adjudicated, I should say. The charges were dropped, and it was never, actually something that was an adjudicated offense. So it shouldn't be really treated as such. Yet that's how it comes up on the record. So as I started to talk about, do juvenile records automatically go away? Well, again, in 2017, the legislature tried to address this issue and said that, hey, for many, many offenses, we're going to go ahead and do automatic sealing at age 19 for non-felony adjudications. And so what's supposed to happen in this process is that when somebody turns 19 in Texas, DPS is supposed to look to see if they have a juvenile offense anywhere. And if so, they flag that record and they send it back to the juvenile probation department where that record was created. And then the juvenile probation department is supposed to do a scan and check the background to see if there's anything that has gotten in the way of this being an eligible record to be sealed, because some things can happen that make that record ineligible for sealing. And so if it turns out that it is still eligible, then they have to send it to the DA's office. The DA's office has to also do that very same check and then send it back to the probation department. And then they are supposed to send an order to the judges or to the judge and to sign that order saying, yes, we're going to seal this record. And then that gets sent out to all of the agencies that I mentioned before that have these records. This is fairly time consuming. And when you're talking about a county like Harris County that has hundreds and thousands of records that are coming through it every year, this is a massive job. And up until recently, HCJPD only had one person assigned to do this work. And so it just wasn't happening really at all. Since COVID, they were able to take some of their probation officers that couldn't do their job because of COVID. Normally, they started doing work on trying to do these automatic record sealing and evaluations. It's still not, I can tell you, it's still not happening the way that it's supposed to. There's whole categories of cases that aren't even going through the evaluation process, and it's still just very, very unwieldy. And I have never had the experience of having a client, call me and say, hey, can you just check to see if my record has been sealed, and finding out that yes, it has in fact been sealed. So I would not rely on that in any way. In other counties, smaller, and I know that's also happening in the same way in Bexar County, in Dallas County, in Travis County. Travis County is a little bit better. Tarrant County, they're having the same issues and problems. And in the smaller counties, sometimes they don't have that same issue, but they just don't really understand how to seal juvenile records. So like when we go in and we have cases in small counties where we want a record sealed, we sometimes have to show that county clerk how the record needs to be sealed because they don't know what that process is. So again, no guarantee that it's happening. So the best practice is to petition the juvenile court for sealing of records as soon as you are eligible. The other issues are that if you have a client that, most clients want to get their record sealed before they turn 19. It's a little bit late in the day, once they turn 19 to do this, because a lot of stuff is happening when they are trying to get jobs out of high school, go to college, go into the military. And then if they have felony adjudications, those are never eligible for automatic sealing. So you must file an application to try to seal those. So if you so what is the eligibility for sealing by application? So this is what you all are going to be doing. Essentially, it's pretty simple. Either your client needs to be 17 years of age or older, or 1 year needs to have passed since the end of the case. Both felonies and misdemeanors are eligible for sealing by application. No determinate sentences, no adjudication of habitual felony conduct, and no current requirement to register as a sex offender. None of those are eligible to be sealed. And if you have an adult felony conviction, you cannot seal your juvenile record. You also cannot have any pending juvenile or adult matters. If there is a pending matter, then you have to wait until that matter is closed and completed before you can try to seal a juvenile record. I mentioned that determinate sentences are not eligible for sealing, just so that you understand what that means. Those are primarily very severe offenses like murder, capital murder. There's a partial list here. And that is where the prosecutor has asked that the person who has committed the offense is going to be on a determinate amount of time, that they're either on probation or committed to TJJD. And that can go past the time that they are actually within the jurisdiction of the juvenile court. And that's why that's called a determinate sentence. Usually, when there's not such a severe offense, they're put on indeterminate sentences where any kind of probation that they're doing or any kind of commitment period that they're in is going to end when they're no longer, of age to be under the jurisdiction of the juvenile court. Engaging in habitual felony conduct, that's essentially 3 felony convictions. Those are not eligible for sealing, and any case where the judge has required that there be a sex offender registration. So that tells you also that there are some sex offenses that are eligible for sealing, as long as there hasn't been that requirement. And that's because, kids can get into trouble when when there's an age range like from 16 to 14 or 13. And that's why those cases can be sealed as well. Just a note that this is much broader eligibility than, I don't know if you all have done adult expunctions or non-disclosures, and in very general terms, those cases, adult expunctions are really usually only eligible if the case has been dismissed, with some exceptions, and adult non-disclosures generally only apply for deferred adjudications, again, with some exceptions. But that is a very, much less broad eligibility range than for juvenile records.
Katya, we have a question from an attendee. If the offense was committed as a juvenile but on deferred adjudication until after 18, can it be sealed?
So that's what I was saying about the youth will never go past the jurisdiction of the court, because even if he's on deferred adjudication for, let's say, 6 months and he turns 18, well, that wouldn't even make sense because deferred adjudication is usually only for 6 months. But let's just say for some reason it goes past his 18th birthday, which would be really hard to do on a deferred adjudication. That probationary period ends when he turns 18. The court no longer has jurisdiction over that. So he would be early terminated from that probation. So yes, it would be sealable.
Thank you.
Sure. So what are the actions taken upon the receipt of a sealing order? So after the sealing hearing, if the judge grants the sealing application, and they are discretionary, so you never, it's never a sure thing that you're going to get, a client's record sealed. But if the judge grants the sealing application and signs the order, you as the attorney will send that signed order to all of the agencies that hold these records, and then they have 61 days to seal those records. And then once that happened, once the order is entered, all adjudications relating to that person that have been sealed are vacated, which is it's a very strong word. They really want to make sure, the legislature really wanted to make sure that these records are treated, once they are sealed, as if they never existed. The proceedings are dismissed and treated for all purposes as though the proceedings had never occurred. that individual can legally deny any previous involvement with any juvenile or criminal proceeding and go forward as if the offense never occurred. So it really is, it is wiping the slate clean. It's very comprehensive and effective. After 61 days, any agency that had once had the records must respond to anyone inquiring that no record exists. And once the person's record is sealed, he or she is not required to state in any proceeding or in any application, including employment, licensing, admission, housing, or any other public or private benefit, that they have ever been the subject of a juvenile matter. Now, there is one caveat with regard to federal records, which I just remember I said that they also go into the FBI record database. So we will talk about that in just a second. More importantly, even than all of that, is you cannot waive that protection. So if you have a sealed record and then you somehow end up like divulging that you have a sealed record to an employer, then that still cannot be used against you. So for example, if that young man who wanted a job with HPD, if he had a sealed record and got that job, but then he ended up telling his employers at HPD that he had a sealed record, they could not use that against him. It can't be used against anybody, even in a perjury prosecution, a civil proceeding, an application process or licensing or certification process, or any admission, employment, or housing decision. So it's very, very strong. You cannot waive that protection once it's been sealed. And again, just to compare this to adult record sealing, because there's some confusion a lot of the time. If you go on the internet and just look up record sealing, you're going to find things that refer to adult record sealing, which is very, very different than juvenile record sealing. Adult non-disclosure is often referred to sealing your record in Texas, but it is not nearly as effective as sealing a juvenile record. That information can still be seen by law enforcement, licensing and regulatory agencies, schools, hospitals, and state, county, and municipal hiring authorities. And you can't deny the offense under oath. All of those things you can do if your record has been sealed. It's essentially gone like an expunction when you seal your juvenile record. But that's not the same thing for an adult record being sealed.
Katya, before you move on, I do have one more question about follow through. So how do you ensure that the agencies have followed through and actually sealed them?
Yeah, so you will see that our orders that we have created, that we have the judge sign, have verification forms on the last 2 pages, and that gets sent out to the agencies, and then they're required to fill those out and let you know when they've complied. And not every agency can do that because, for example, like DPS has an automated system, so we don't get anything back from them. But we have audited all of our cases every summer to check to see, are these agencies complying with what they, are supposed to do? And it turns out that they are. Like even the DA's office, which we were kind of worried about because they also don't send back their verification forms. They are doing what they're supposed to be doing. And I see that also in daily practice because when I have dual status youth who I've represented in their juvenile offenses, if they then go on, if they stay in the system, in the foster care system through to the age of 18, and they've picked up some type of adult offense when they turn 17, if their juvenile record was sealed, I don't see it in the DA's file anymore. Whereas if it hasn't been sealed, that is one of the first things I'm going to see in the DA's file is there is a list of their previous offenses, including their juvenile offenses. So we are very confident that this is happening, that we've seen, like through our audits and through practice, that this is an effective process and the agencies are complying with what they're supposed to do. But with a caveat, which is that the FBI is actually, they're not beholden to, they don't have to follow a state judge's order because they're, a federal agency. So they wouldn't really have to comply with an order, but it turns out that because of an arrangement that happened a long time ago, which I don't even really understand how that happened, they do comply to a certain extent, which means that they will actually get rid of any record information in the FBI records. So there won't be, an indication of what type of offense it was or any records that related to it. However, it will still say that there was an offense, but that it's been sealed. And so because of that, if you have clients that are seeking to enlist in the military, they need to know that they can't deny this record when they want to try to enlist with the military. They have to divulge it. And more importantly, they should probably have all of their record information accessible to their military recruiter, because often military recruiters want to see everything about that record to make sure that they're not just taking that enlistee's word about what the offense was. So it can create problems if somebody gets their record sealed and then wants to enlist in the military, and the military can't obtain those records anymore. So we often tell our clients to at least go talk to your recruiter first to figure out what kind of record information they need, or get a copy of their full records, and then start sealing prior to talking to their military recruiter. But it can't be something where they proceed as if it's a state agency. Same thing with immigration issues. Immigration attorneys that we work with always want us to wait until we start sealing, until they have the records that they need. But they still want us to seal it because it is helpful for their court case in immigration court. But again, the juvenile court and the immigration attorney wants to see those records prior to doing that.
Katya, one follow-up from that. For the military, the question is it best to expunge once they get a full copy of the records?
Best to, you mean
So
best?
I think maybe the question is better to wait until they're an adult. I'm not sure, maybe to clarify.
Well, okay, because I'm the word expunge is throwing me. So a juvenile record cannot be expunged. It's only, this process is the only process that's available to a juvenile record, is sealing it. But as we said, it's very, very close to being an expunction. This federal records exception applies to adult expunctions as well. It's very, very hard to get rid of a federal record entirely, and I'm still not even exactly sure how you do that. I'm learning about that right now, so hopefully I'll have an update about that. But if you get an adult expunction, you also will still have the same thing on a federal record that you will have when you seal a juvenile record. So I guess I hope that answers the question. If it doesn't, ask it in a different way and I'll try to answer it again. The general timeline for sealing a record, that's about 3 months from the time that you meet with your client and start drafting your pleadings to the time that the agencies have sealed their records. So your work will probably be around 1 month as an attorney. And then once you've sent off that order to the agencies to seal them, they have 61 days. So from start to finish for your client, they have about 3 months that they need to be looking at for their record to be sealed. Just to talk about the different types of dispositions so that you have an understanding of what happens in juvenile court and how cases can be disposed. You've got, number one, those pre-petition intervention programs, like we said, the DP programs, the FIRST program. They are, again, no charge will be filed, there's no court appearance, but there will still be a juvenile record that has been created that will not go away until sealing. Deferred adjudication or deferred prosecution, that's something that happens in court. Either the prosecutor can offer a 6 month, it's usually 6 months deferred adjudication, where they are on probation prior to being adjudicated. And if they are successful on that, then those charges then that case will be non-suited. It will be dismissed. So again, there will not be any charge on that. There'll be a charge, but it will be dismissed. So it'll be like no adjudication happened. Non-suit, that's if the case is completely dismissed for lack of probable cause. Formal adjudication or community supervision or commitment, those are all basically words to say that there was what would be a conviction in adult court. It was adjudicated. The juvenile either pled true to engaging in delinquent conduct, or he was adjudicated as having that it was true that he committed delinquent conduct. The typical punishment for these is community supervision and sometimes commitment, but you're not going to see a lot of those cases for these sealing cases. Determinate sentencing, again, that's what we talked about when there has been an actual period of time that the juvenile is sentenced to that takes them beyond the jurisdictional age of the juvenile court. Again, all of these dispositions creates a record. I'm just going to really quickly talk about a few felony case examples, because we are encouraging you to take felony cases. Probably, I mean, we've talked about this, maybe not for the first one that you take on, a misdemeanor until you can get your feet wet is probably the best way to go. But felony cases in juvenile court look very different from what they look like on paper when you start investigating what happened. So, for example, we had one young man who oh yeah, I remember this case. Okay, so he was he's 17 years old. He comes to us. He's applying to college. He has straight A's, and he and a friend, and he's being courted by like Ivy League colleges because he really is like a stellar student, a stellar athlete, has everything going for him. But when he was younger, like 15 years old, he and a friend, their school building was under construction. So they went in at night because the doors were open. They could easily just get in just to take a look around. I mean, they were kind of like, let's just do that. This should be fun. And when he was in there with his friend took a yearbook. He was like, oh, I want this yearbook from, I guess, out of the library or somewhere. And as they were leaving, they were arrested by the cop who was, patrolling the building. And they were charged with, felony burglary of a building, because that's what that category that it fell into. And, it went on deferred adjudication. They didn't, they weren't adjudicated with that. However, that offense looks really bad on a record. So that's the kind of thing where, I mean, a felony can look much worse than it is. Same thing with that kid that when he was walking down the street where he was charged with a felony robbery that he never committed. And then we have a lot of aggravated assault on family member cases, where it's really more where a case of where the kid is kind of out of control. The family dynamics are unstable. The parents don't know how to handle the kid. And so either to teach them a lesson, they will call the cops and like just have them put in detention because they don't want to take that, they don't want to deal with that kid anymore. They basically just want them out of their hair, and either just make them like teach them a lesson so that they'll act differently, or they really can't, like, they don't know how to discipline that child anymore. And so it ends up being something where they're using the juvenile justice system as a disciplinary force, but they don't realize that that's making that kid look like, somebody who's assaulted their family member for the rest of their life on their record. And that's going to impact them long-term for many different things. So of course, in hindsight, when parents understand this, they are horrified. So this is also, again, one of these things where it looks really bad, but like if you get into the case, it's something you really do want to seal. Somebody asked this question, how do we know it works? Like we said, the DA's file shows it to us. When we talk to military recruiters, if a case has been sealed, they can't access that record. They know it's there, but they don't know what it is. So they don't have, any idea what it is. So we know it works, at that level with the FBI. We know that HCJPD can't access it anymore once it's been sealed. And again, we have done audits, so we know that the other agencies are doing what they're supposed to be doing. So what is the essential overview for a case like this? You will draft an application, a proposed order, an interview form, and an engagement letter. You'll have your client meeting where you will have them sign the engagement letter or pro bono legal agreement. You'll interview them about the offense. You'll explain the sealing process and what the expectations are and what the legal effect of sealing is. Once you have that and you've drafted your application in order and finalized it, you'll file that with the court and schedule a hearing, and then serve the agencies, all of the agencies that you've determined need to be served on this case. You'll serve them with notice of hearing. Then you'll attend the hearing in juvenile court if it's opposed. If it's an opposed case, hearings will be required. However, thankfully, ever since COVID, if it's not opposed, you do not have to go to court for a hearing. And this is something that I had been trying to get into place for a really long time, but thanks to COVID, it finally is happening, where if the prosecutor is not opposed to sealing, the judge will sign it on submission. So it's actually much, much easier process than it used to be. Once you have obtained a signed sealing order from the judge, you serve the agencies with that order, and then they will do what they need to do. And once you've served those agencies, you send a closing letter to your client, as well as a copy of the order, and you're done. That's the basic timeline and process. And I'm not going into the nitty gritty of it, because if you guys are interested, we will actually do a real training. But essentially, that for that meeting prep, you just draft your application and order, you prepare an engagement letter, you prepare your client interview form, and you have a client information handout that you get ready to send to them or give to them during the meeting. Drafting the application and order, we've made very, very simple and straightforward. We have created essentially fillable forms, so it is very difficult to go completely awry on these. There is language for every type of disposition that we have included on each order template, so that you can pick and choose which one is applicable. And most all of the information that you need is going to come from the sealing forms that you get directly from HCJPD. So it's really a matter of just cutting and pasting from one form to another, and you will have everything you need other than the client's race, social security number, and driver's license number, because those are all required for the application and order, but you can't get those from the sealing forms. You have to get those from your interview with your client. As well as which additional agencies might need to be served, although many of those are going to be obvious from the sealing form as well. The client meetings, we've been holding all of ours via phone call or Zoom since COVID. So that again makes it a lot easier and more expedient. As long as you can have your client sign the pro bono agreement somehow, we use DocuSign, then there is no real necessity for an in-person meeting. Filing the application and order, again, this used to be something where we'd have to do this we'd have to walk down to the courthouse and go to the office where this is done, which was, a lot of work and time spent on parking and getting to the courthouse for something that can now be done via email. And it makes things much, much easier. Both setting the hearing date and filing the application and order is something that is done via email. Serving the application and order. As you can imagine, there are many, many different arresting agencies, police departments, precincts, where these offenses can originate from. And it used to be, again, that for each one of these, we'd have to track down, who's the right person to try to serve for that police department. Again, also with the school districts, there's many, many different schools and school districts that have different people that need to be served, and they have different requirements for service. We have an extensive service contact list now, where almost everybody that you might come into contact with that might be an agency that needs to be served on one of your cases is included. Sometimes there's like a very random small police department that we haven't gotten to yet, in which case you have to track them down. But otherwise, it's really just right there on the list. So it shouldn't be at all difficult to find on how do you serve them. And also, for the most part, it's all email service. Again, there's a few that require certified mail service, but very, very few. Once you've done all of that and you have a hearing date set, 1 week prior to your hearing date, you'll contact the chief prosecutor of that court regarding whether they're going to be opposing it. We have those chief prosecutors listed and their contact information in your guide. And if they're unopposed, again, all you have to do is notify the court clerk to submit that order to the judge, and it will be signed on submission by the judge. If it is opposed, prepare your argument for hearing. And again, if you want to take these cases and you don't ever want to go to a courtroom and ever argue a case, then take the minor cases, take the misdemeanor cases or the deferred prosecution cases, and you will likely never have to argue one of these cases. However, if you'd like to, and this is something also to get experience, just arguing in court, felony adjudications will very often be opposed. And if that's the case, you're going to want to have your client there in case, there needs to be any type of evidentiary support in person from your client. And then the essential nuts and bolts of that argument are Why is that client eligible to seal? How much time has passed since the closing of the case, where the client has not been in any further trouble, especially in cases where there's been many years, and often there are many years in between when that case was closed to when that client is now trying to seek sealing. The positive things that client is doing in their life: job, school, grades, attending school regularly, even if they aren't getting great grades, sports accolades, commendations, volunteer service, taking care of family. Those are all things that the judges are going to look at. It doesn't have to be that they're like star students or anything like that, but if they are doing, or if they're staying out of trouble, and if they're doing something good, like even if they're taking care of an ailing family member, that's still, showing that they're staying on the straight and narrow, and they're trying to do the right thing. We had one kid who he participated in an armed robbery with a friend of his, and he did not actually have the gun. He did not touch it. And he, just made very poor choice about doing this because he needed money for his family. But since that time, he basically completely changed schools, no longer associated with the kid who did this. Attended school regularly, wasn't getting super grades, but was doing, definitely going to school regularly. He was a sports star. He was being looked at as being recruited for the football team of his school. So we could show, like, he had, like, Houston Chronicle articles written about him, about his sports prowess. And so that kind of thing, I mean, the judges just want to see, like, how different is this kid now from the kid who did something like commit an armed robbery with a friend of his. You don't necessarily need any outside evidentiary support in all cases. If you have the client there or the parent there, in addition to the client, or family member who can attest to things that the client is doing, that is good evidentiary support. But if you can also show things like support letters, good report cards, sports commendations, things like that, you can submit those in support of your case. Then, you're just going to serve your signed order. That is, very, very simple, much like serving the notice of hearing. You're just going to have to scan in the signed order that you get. That won't be emailed to you. It will be mailed to you, and then you have to scan it in with that, including the certified stamp that is on the back of that order, and then just send it to all of those agencies that you have listed on your agency service list. And that is my PowerPoint, and hopefully I haven't gone over time to answer some questions.
No, it's great timing. Thank you, Katya. We do have one question from an attendee referring to unsatisfactorily terminated on a deferred adjudication. Can that be sealed? Can you address that, please?
Oh, I'm sorry, can you say that one more time?
Sure. For a deferred adjudication that was unsatisfactorily terminated.
Okay, yes, those are still sealable. It makes it a little bit harder, but so, like, if it's a deferred adjudication and they ended up like violating that, and it became like an actual adjudication, which is what usually happens with unsatisfactory deferred adjudications, that's then just a regular adjudication, which you then have to, like, say, yeah, they didn't do what they were supposed to do, and then so turn it to an adjudication. But look at all this time that has passed since that time. And it's the same thing if, let's say, they were on a deferred adjudication and it just was terminated due to aging out, and lack of jurisdiction of the juvenile court. It doesn't look great, but you can say, that's right, he didn't do what he was supposed to do back then, but look at what he's done since then. I mean, that's really what the focus of your arguments are going to be for these kids, or these young adults, or even maybe older adults now.
Awesome. Thank you for addressing that. Is there an appeals process if in a contested proceeding the judge refuses to seal?
Well, not really. There's not one that's I've ever been able to find anywhere in the law. However, it's actually never come up. I've never been in front of a judge who said, I'm not going to seal this. What they generally do is they say something like, it's a little early. This is especially with the younger clients who are like 17, 18 years old. And the prosecutor is saying, look, I don't even know if I can't tell at this point whether this kid is really not going to get into trouble again, so I don't want to seal it. And so the judge may, in those circumstances, say, look, I agree, I don't want to seal this yet. Let's, reset this to 6 months from now, a year from now, and revisit and see if it's sealable at that time.
Thank you. Let's see. Just for those who are and who need to scoot out, the CLE information is posted here, as well as information of how to reach out to the new Attorney Pro Bono project or to volunteer with Houston Volunteer Lawyers. Our information is here. I will, of course, get through the remainder of the questions, but I wanted to make sure that that was there. If you are watching this as a recording, be sure to use the second number, that 3550 instead of the one previous. There is a question about the appeals process and if the same volunteer will be responsible to handle that. That will really depend on your staff attorney mentor, and if you're able to stay on the case. Of course, it would be preferred because of the relationship that you've developed with the client. But if there is a time constraint or something along those lines that you wouldn't be able to continue in that process, the staff attorney mentor can assist you with finding another volunteer. Another question from the attendee: do you have experience with record sealing applicants who also hope to apply for DACA status? Would that applicant need to disclose this on the DACA application?
Yes, and again, this is where we always say, if you've got a client with an immigration issue, including DACA, we want to talk to that immigration attorney, or we want to make sure that that immigration attorney has looked through all of those records and actually said, yes, I've got what I need. You can go ahead and start sealing now. But without that happening first, I would not move forward with sealing, because then you're making it much harder. Because once the record is sealed, you cannot get any underlying record information anymore. It's that immigration attorney can't get any kind of record information that they might need to present to the court, or to make a determination about whether it's going to impact that DACA case. So again, ask your clients, do they have an immigration issue? If they do, be in touch with that immigration attorney and just make sure that that immigration attorney says, yes, go ahead. You've got my go ahead.
All right, it looks like, thanks, Susan, for the feedback. We're getting some positive feedback from the attendees, Katya, so thank you for your time. Another question from an attendee: so is this the same to get all the this is about the tobacco cases when it comes to applying for the military? Would this be the time to get all of those documents as well?
Yes.
Excellent. Is there anything that we can do to make the county seal the record automatically rather than having it to be on a case-by-case basis or discretionary?
Well, give them money. I mean, they have, they're constrained by the amount of, this was an unfunded mandate when the legislature, put this into place. So there was no extra funding provided to try to allow for these large jurisdictions like Harris County to have people be able to do this process, right? We are investigating a potential way to automate this system somehow to make it more feasible for big counties to do automatic sealing. We are actually some people, members of the HBA and I and Texas Appleseed have been in contact with people who are data integration systems people, and apparently this could be done in a way that could be much, much, much more expedient and easier for big counties like this to do this process. But right now, that's still in early stages of discussion.
Thank you. Let's see. I think those are all of the questions. If anyone has additional questions, Katya, you were sharing your contact information. Would you mind also just typing it in the chat for those, since I am still sharing my screen here for the CLE info. The presentation, as we mentioned, will be recorded and uploaded to our YouTube channel. I will post that again here, but then also be sure to look at our Facebook page for Houston Volunteer Lawyers, as well as for JCAP, to be able to have that information for the recording. And if you have additional questions, feel free to reach out to the new Attorney Pro Bono Project. Visit www.makejusticehappen.org to sign up for our volunteer portal. And even if you're not ready to take a case right now, you can still sign up for the portal, be able to look at active live cases, not only juvenile sealing, but also all of the other civil cases that we take on. And it's very easy to pick a case that way. So again, Katya, thank you so much for joining us today. We are looking forward to having a second or a part 2 of this training for those who are ready to take a case. As I mentioned, we have live cases ready to go, approximately 20 or so that are ready for volunteers. And so we will have a second training over the next few weeks so that we can get you guys ready to apply for sealing. Thanks again. We hope everyone has a wonderful week and have a great day.
Thank you. My pleasure.